Okay, well, good afternoon, everyone. Thanks for spending your lunchtime with us. Hopefully we can give you some good, useful information about the process. For some of you, this will be a refresher because you're familiar with the process, and it might serve as a good refresher for for getting an H-1B at your workplace. For others, this might be new, but try to make it interesting for those who are familiar or not familiar with how to do an H-1B. So there's a delightful picture of me, which we will ignore, but it's on the slide so you can take a look at what my practice is. In any event, this is an overview of today's agenda. We're going to talk about H-1Bs in general, what the benefits are, why even try for one. We're going to talk about this concept of a specialty occupation, what it is, and why it's key in the H-1B context. Talk about specific steps to getting an H-1B. What are the challenges in getting an H-1B approved and ways to overcome them? What about dependents of H-1B workers? What kinds of benefits can they get? And possible alternatives to getting temporary workers if the H-1B isn't possible. And after our talk, hopefully we'll be able to field some questions and have this be a back and forth, which I would welcome. But before we get into this, let's just talk generally about where we are. So let's see, the H-1B program has been around since 1990. It's been reached, so H-1B is a temporary work visa program. There are only 85,000 visa made available each year by Department of Homeland Security and Department of State. And every year since 2004, that visa limit has been met. And in fact, every year since 2014, so 14, 15, 16, and this last year, fiscal year 17, which started in October, the 85,000 visa limit was met in April, which is the first date this visa is available to be applied for. We'll talk a little bit more about how the cap works and and the timing around the cap for H-1Bs. So last year in April, the first week in April, which is the only time new visa applications for this particular category visa were open, USCIS, which is under Department of Homeland Security, received 236,000 applications for 85,000 visa spots. Cap was reached, like I said, immediately that first week, and then there was a lottery that was in place. This year we expect that the cap to be also reached within the first week in April, and so applications that are subject to the numerical limitation on H-1Bs will also be subject to a lottery in April. Now, the current climate is a little bit different. I know there's a lot of news reports on sort of the toughening stance that we are taking on immigration in general. But I guess, and there's been a lot of talk about H-1Bs in particular, even before the election. Now, but the bottom line is nothing has officially been changed or ordered by this new administration. There's a lot of speculation that the program's going to be tougher, a lot of speculation that there'll be more scrutiny on every aspect of this program. We'll go through the steps of where we need to be careful, where pitfalls might occur. But in terms of quotas, in terms of wages, nothing has officially been signed to make the H-1B any different than it was last year. The things that we don't know is how they're going to be adjudicated, and we can only assume that the adjudication of these is going to involve a little more scrutiny than they have met in the past. Where I believe a lot more scrutiny, the companies that will invite the most scrutiny are companies that are involved in consulting, where you have employees that are working at client work sites, working remotely. Those are the types of situations where Department of Homeland Security is I believe, is going to focus most of its enforcement and scrutiny in terms of the H-1B. So that's as far as that goes. Among the pieces of legislation that have been proposed, and again, proposed but have not been passed, and again, not likely to be approved before the April 1st H-1B season gets underway, among the bills is this bill that would increase the minimum wage for any H-1B to be $130,000. Again, there's been a lot of rumors and a lot of press about these kinds of bills, but again, nothing has been approved, and again, likely won't be approved before then. So again, the only thing we can be assured is that there will be more scrutiny of H-1Bs, any H-1B that gets that is filed this year. So moving on, let's talk about what an H-1B is and what are the benefits of it. So H-1Bs generally valid for up to 3 years at a time, for a total of 6 years. You can go beyond 6 years if you have a worker who's pursuing permanent residence through an employment-based visa and is from a country that is oversubscribed in the parlance of Department of State, or who comes from a country where there are just too many applicants in a particular category of employment-based visas. In particular, in the H-1B world, those workers tend to be from China and India, very long waits. But if you have an approved immigration petition, but you're just too far back in the line, you would be able to then extend your H-1B status for beyond that 6 years. But generally speaking, they're good for 3 years at a time, total of 6 years. These are, of course, non-immigrant visas. In the world of immigration law, there's two types of visas. There are immigrant visas. There's immigrants and non-immigrants. Immigrants are according to the law, are people who are going to move and live here permanently. Non-immigrants are everyone else. Non-immigrants includes visitors and temporary workers. H-1B is a temporary worker visa. That's something to remember, because again, H-1Bs tend to be a gateway to becoming a permanent resident through the employment-based immigration process. But the H-1B itself is a temporary visa, and the government treats everyone who's on an H-1B as someone who's going to be here temporarily and will eventually go home. Now, having said that, a lot of visas, most visas in fact, carry with them an inherent intent that the person applying for the visa and being granted the visa are making a commitment to the U.S. government that they intend to return and they do not intend to immigrate, i.e. move here and live here permanently. The H-1B does not have this requirement. Hence the second bullet point, immigrant intent is not an issue. So you can have it, you can be a beneficiary of an H-1B, and at the same time you can have an immigrant petition filed for you. That doesn't necessarily make your H-1B invalid. So this is a pretty nice perk if you have a worker who's here temporarily, but maybe you want to transition into a permanent resident situation. That's why H-1B is a very good way to provide a pathway to permanent resident. And finally, contrary to popular belief, there's no recruitment required for an H-1B. There are requirements, but recruitment is not one of them. You don't have to prove that there are no U.S. workers willing, qualified, or able to take that job. What you do have to prove is that there's a member of a specialty occupation. And what is a specialty occupation? Well, specialty occupation, that first long bullet point we have here actually comes straight from the Department of Labor regulations on the subject. Now, basically what that means is it's a person who has a minimum of a bachelor's degree in a specialty occupation or its equivalent, and that the job that the person is being slated for actually require that same degree or equivalent for that position. That's the first hurdle to meet. If a person has a bachelor's degree in a certain subject and the position requires a bachelor's degree in that certain subject, then more likely than not they will qualify for an H-1B. Now, process itself is because a lot of folks who apply for an H-1B are subject to this 85,000 visa cap. A lot of this process has to start either now or at the very latest sometime within the next week, because immigrant benefits can only be applied 6 months in advance. The fiscal year for the federal government starts on October 1st, which means that by April 1st is the earliest you can apply for government benefit, including immigration benefits, H-1B visas being one of them. So April 1st is the earliest you can apply for an October 1st start date for an H-1B. So all of the filing of the H-1B petition, which is the sort of middle box in this process, that has to be done by April 1st, or at least within the first 5 days of April. Immediately before that, though, the first step in the H-1B process is to settle on a job description, to make sure that job description and the occupation it describes actually requires a bachelor's degree or its equivalent, that your company actually, if they've hired someone in that position before, has always required or typically requires a bachelor's degree, and that the person you're trying to hire has a bachelor's degree in the area that you are seeking. That will determine what the particular wage level for that position in your area is. There's a wage schedule put out by the Department of Labor that's a pretty good rule of thumb that we typically use at the outset to try to figure out what the correct wage level is. This is sort of the key threshold consideration before you start any of that process, the job description and figuring out what the right wage is. What the right wage is important because you cannot offer a wage to an H-1B worker that is below what the Department of Labor believes someone at that job in that geographic area should earn. So that's number one. Once you decide that, there's a labor conditions application, which is filed with the Department of Labor in Chicago. It's basically a commitment to the Department of Labor that for the next 3 years you intend to hire an H-1B worker for this position at a certain wage, at a certain location. And that takes about 5 days to get approved. If the company has not filed a labor conditions application before, you have to add a week before that, because then the company has to get its federal employee ID number verified. So that's the first step in the process. Second step of the process. Once that's completed, you maybe take a week to get the federal employee ID number verified, another week to get the labor conditions application certified. Then you're ready to prepare your H-1B petition. The H-1B petition would be supplemented by the worker's resume, the worker's evidence of his or her academic credentials, evidence that the job being described actually requires the academic credentials described in the job description, and that the person actually has them. In addition to if they're in the country, if they're here, if they are in status, and if they're not in the country, at least the evidence of that they can travel to the U.S., i.e. if they have a passport, and if any prior history they've had in coming to the U.S. At a general level, that's in addition to the I-129, which is the main application that must be completed to actually file for the H-1B. From there, there's 3 possible sort of paths. If you're already here on an H-1B, you're just talking about an extension of stay, which basically allows you to extend your stay in H-1B status, possibly beyond the 6 years, as we talked about. That's this H-1B portability issue. If they're outside the U.S., then once a petition is filed and it's approved, then it moves to the Department of State, and the person who's outside the U.S. then must interview at a U.S. consulate or embassy outside of the U.S. and apply for a visa to enter the country. If the person is in the U.S. in a different status, for instance, they're here as a student in an F1 status. That's a very popular path that a lot of people follow when they're in the U.S. They go from student in F1 status, either as a student or as a student when they first apply, or as a student who's doing occupational practical training post completion of their degree. They would be able to apply for something called change of status, which allows them to change from their current visa to an H visa without having to leave the country. And the earliest they would be able to start would be October 1st if they're not CAP exempt, if they're not exempt from the CAP. And we'll talk about what types of people are exempt from this 85,000 visa limit. Now, some of the challenges the H-1Bs face. So, U.S. employers are subject to this cap. What is the cap? Well, the cap is this. USCIS accepts 65,000 applications for H-1Bs every fiscal year. As I mentioned, a fiscal year goes from October 1st to September 30th. This 65,000 includes Chinese and Chilean workers, but they get counted first. We'll talk about that a little bit later. As I mentioned, every year since 2014, and most years since 1990, the cap was met in April. So, which means that if an employer has to file on April 1st for an effective work date of October 1st with no guarantee of approval, meaning if you are able to get it in April 1st, if USCIS decides that they've received more than enough to satisfy the 65,000 H-1B quota, then what they'll do is they'll select the applications based on a lottery. And like I said, that you would keep every applicant, every business who applies for an H-1B would know if they're going to be in or out of the lottery pretty soon in April. By mid-April, you would know whether or not you made the lottery. If you made the lottery, then USCIS continues its normal processing. And processing at this point, based on our experience last year and even throughout the year for applications that were not subject to this 65,000 H-1B cap, it's taking about 6 to 9 months to approve an H-1B. Now, there is a way around that, of course. It's something called premium processing, which allows a company to buy, basically, time. And so for an extra $1,200 in addition to the filing fees for an H-1B, you can ask the government to decide your case within 15 days. And so the regular filing fees, which could be as much as almost $2,500, if you add to that another $1,225, if you make the lottery, if your H-1B is subject to the cap, if you make the lottery, and then if you have premium processing, then you would be able to know potentially by the end of April if you have an H-1B worker who's going to be able to join you on October 1st. And sort of the final challenge is this specialty occupation. It's a threshold limit. You need to, it can't be just any worker. It's got to be a worker that has a bachelor's degree or higher, or the equivalent of a bachelor's degree or higher. And they have to be seeking a position that requires that degree in a particular field. One caveat to that is that not every degree is the same. General liberal arts degrees more challenging to approve. Business administration degrees and marketing degrees likewise. Why? Because the Department of Labor and the Department of Homeland Security view those kinds of positions as sometimes requiring a bachelor's degree, but sometimes not. And so if a position can be done without a bachelor's degree, then the default judgment on those kind of positions is that it must not be a specialty occupation. So that's something to keep in mind when deciding to move forward on these kinds of petitions, to really assess whether or not the position you're thinking about is actually a specialty occupation, and if it's not clearly a specialty occupation, to work with a professional to try to decide what about the job or what about the position needs to be beefed up or needs to change in order to qualify for something like an H-1B. And if it doesn't qualify for an H-1B, what are the alternatives there might be, which is one of the last things we're going to talk about. Now, we talk about the cap. There is, as I mentioned, there are a limited number of these visas. They're capped at 65,000 for general H-1Bs. If you have a master's degree, you apply for an H-1B position, and the position requires an a master's degree, then I take that back. If an H-1B worker has a master's degree, then there are an extra 20,000 visas available for master's degree holders, and there have to be U.S. masters or higher. So certain workers, though, are exempt from the H-1B annual quota. And who would those workers be? It would be primarily workers who have already been counted against the cap within the previous 6 years. So if you have a worker who has been an H-1B for the last 3 years, and they're moving from one company to another, and they're applying for another H-1B, it's not a new H-1B. They've already been counted against the cap. You don't have to count them again. In fact, a worker like that can move from one company to another company who's willing to sponsor them for an H-1B at any time, because again, the October 1st and April 1st dates and deadlines only refer to workers who are subject to this cap. So if a worker's been counted against this cap, they wouldn't be counted against it if they've been counted within the previous 6 years. Some other types of workers who've been able to recapture H-1B time. What does recapture mean? You're only in H-1B status if you are in the country. If every day, every time that you're out of the country for whatever reason, be it for business or vacation, it's time that you are not using your H-1B. So if you have a 3-year visa, 3-year status as an H-1B holder, and your company requires you to travel abroad, I've seen instances where people can recapture as much as a year time. At the end of their 6 years, if they keep track of every time they were out of the U.S., again, they wouldn't be subject to an H-1B if they can recapture that time outside of the U.S. And once again, we talked about this issue of workers who have master's degrees or higher. They get an extra 20,000 slots, and they would get selected first. So the way it would work is if you have these, let's go with the example of 2017. There were 236,000 applications. What USCIS did is they segregated all of the master's degrees, and they tried to match the 20,000 visas to those. Anyone who didn't make that first cut in the 20,000 then gets put back in the general population of H-1B applications, and then the 65,000 visas would get allocated accordingly. The final sort of exception would be this. There's 6,800 visas set aside for workers from Chile and Singapore. Again, if you have an H-1B applicant who's a worker from either Chile or Singapore, they would be set aside. The first 6,800 visas would be available to any Chilean or Singaporean worker who qualified. Any numbers that aren't used or any visas that aren't allocated to Chileans or Singaporeans then go back into the general pot, and then the remaining workers would be able to take advantage of those. To my understanding, the Chileans and Singaporeans for the last couple of years have not met that cap. So if you have a Chilean or Singaporean worker, they want to apply for an H-1B, they have a pretty good chance of getting it. Now, not only are workers subject to this exception, but organizations are as well. And the primary example of an organization that doesn't have to worry about the cap are institutions of higher education. So if you work for any kind of school, obviously higher education, so community college, or your college, technical college, and you would like to hire an H-1B worker, you do not have to worry about this cap. You do not have to worry about April 1st or October 1st. You do have to worry about the application process and meeting all the requirements for an H-1B, but the cap season would not apply to you. And so you don't have to worry about the lottery or anything along those. Government agencies or not-for-profit organizations that are primarily engaged in research. So if you're an engineer, if you have a position in the Department of Public Works in the city of Milwaukee, you wouldn't qualify under this exception. But if you were working for the EPA, working on water quality research projects, then you might. Finally, any non-for-profit institution that's affiliated with the institution of higher learning would also qualify for this. And physicians in general who are here on J-1 visas. J-1 visas are restrictive in the sense that if you have one of these visas, you're required to actually go back to your country for at least 2 years before you can then come back and apply for another immigration benefit. Physicians that have a J1 and agree to work in a service in an underserved area would apply for an H-1B exception, meaning they wouldn't be subject to the cap. Now, in terms of, now we've talked about generally what the H-1Bs, what the H-1B workers are and what they have, what they can do, and how you can apply for that kind of visa. But dependents also are able to come to the U.S. to live as dependents of the H-1B worker. Up until relatively recently, about 2 years ago, H-4s, which is the visa category for dependents of H-1Bs, H-4 visa holders, although entitled to come to the U.S. and to accompany their relative, either its spouse or parent, who's an H-1B worker, they were not entitled to work. So they could come here, they could live in the U.S., they could go to school in the U.S., but they couldn't work in the U.S., which caused a problem for a lot of people, especially if you had an H-1B worker who was hoping to transition into a permanent residence and is a citizen of an oversubscribed country and has to wait quite a while to get permanent residence. This could cause a problem because you have spouses who basically had to sit in the U.S. and not work legally, waiting for work authorization to arrive. That changed, like I said, 2 years ago. And so now, H-4 visa holders actually have a limited right to work. They have to show that the H-1B worker is a beneficiary of an approved employment-based petition, and that the H-1B worker has been granted more than a 6-year extension, past the 6-year extension. Now, so you do all this work, you find someone who potentially could qualify as an H-1B, you prepare the application, you file it on time, and you're not picked in the lottery. Are you out of luck? Not necessarily. Depending on where the person's from and the kind of position it is, you might have other alternatives to actually get that worker to come to the U.S. and work for you. One popular, here's a list of some popular alternatives that are used, and again, depending on where the person's from and depending on the type of employee that we're talking about, type of position we're talking about. First popular alternative is TN status. This is a visa category that was created as a result of the implementation of NAFTA, the North American Free Trade Agreement between the U.S., Canada, and Mexico. It allows, among the provisions of NAFTA, it makes it easier for specific occupations, mostly specifically specialty workers, very skilled workers, to move back and forth between the 3 countries. These are valid for 3 years, and there's no outside limit. Basically, you can renew them for as long as you need the worker. And again, they're available for Canadians and Mexicans to work in the U.S. The H-1B1, which is I alluded to earlier, has to do with Chilean and Singaporean workers, similar to the H-1B, but it's granted for only 1-year increments. And there's no outside limit. So they can be renewed for as long as you need the worker. Also, no immigrant intent. The TN visa does have immigrant intent. So if you have a Mexican or Canadian worker in your workforce that's in TN status and decides that perhaps they want to move here permanently, that is something to keep in mind in terms of getting this visa, because as soon as they make any sort of affirmative steps, take any affirmative steps towards permanent residence, then that visa could be invalidated. H-1B1 doesn't have that, just like the H-1B doesn't have that element in it. So, and again, the first 6,800 visas in the H-1B category are going to Chilean and Singaporean workers for the H-1B1 program. E3, the E3 visa category is only for Australians, similar to the H-1B. It's not subject to any quota. So basically, if you have an Australian that meets generally the same qualifications as an H-1B, you can always bring them here. You don't have to rely on the H-1B. You could potentially rely on this E3 category. Again, no quotas. It's always available. The final sort of popular alternative to bringing someone to work temporarily on a kind of a specialty level would be the L1. The L1 is a intra-company transfer visa. It's multinational. It's for multinational corporations. You have to have operations in the U.S. and abroad, and the person who is the beneficiary, the worker who's a beneficiary of this visa, has to have worked at an affiliate company outside the U.S. for at least 1 year within the preceding 3 years. And they have to have had either an executive or managerial position outside the U.S. or a person with specialized knowledge of the company or the product of the company. If you can meet that threshold, then that person would potentially qualify to move to the U.S. for a period of 5 years. That's how long the visa are granted for. And they could be renewed. And there's no cap subject. And which means that whenever you find a worker like this, if you qualify for something along these lines, then you can always bring someone like this to the U.S. without having to worry about if the government rations how many of these visas are available. The government does not. The other kind of nice thing about this one is that there also is no immigrant intent. Someone can apply for this visa and also at the same time apply for immigrant benefits without jeopardizing the intent element of the L visa. So that, in a nutshell, is the presentation. I usually like to do this as more of a back and forth. I'm hoping there's questions out there that I can answer for people about this process. So I'm happy to take any questions you might have.
During this time, we will open up the phone lines in case anyone would like to pose a question verbally. Alternatively, you're welcome to continue to utilize the send a note to all presenters feature in the system to submit your questions.
All participants are now in interactive talk mode.
Whether you do so verbally or through the system, you're welcome to remain anonymous if you so choose. The phone line is now open. Please proceed. Thanks. While we're waiting for folks to submit questions, I will remind you, especially for folks who joined late, we will circulate the materials after the program in case anyone joined late or just otherwise would like a copy. Certainly you're welcome to submit questions to Hugo directly after the conference concludes as well. Hugo, you may want to flip back to your contact page so folks can make note of your contact information.
Will do. That would be...
Go to page 2.
Thank you. Okay.
And with that, if we don't have any questions, we will conclude for today. Hugo, any closing comments?
No, I would say that this is, at the outset, it seems like it could be it seems like a daunting process, but thousands of companies take advantage of this process every year, and it's certainly a popular part of the American workforce. So be happy to help and advise and answer any questions as they arise.
Thank you. And that concludes our program. Thank you, everyone. Stay tuned for the materials and a copy of the recording. Have a good afternoon.
All participants are now in listen-only mode.